My lord, I'm not here to mention anything, my lord. I'm here to inform the court that in today's list, one Group 7 matter has been listed as Group 1.
দিদি দেখে নেবেন
Number is item number 6.
দুজনেই আসেননি আজকে কিন্তু নাম্বার প্লিজ
My lord, may I permit it to mention, my lord?
7 এ লিস্টেড হবে হ্যাঁ
27 বুঝেছো
হ্যাঁ?
বুঝেছো
The matter can be after
33
যার list এ আসেনি বলতে।
এসেছে গ্রুপ 7 হিসাবে এসেছে গ্রুপ 1 এ হবে না 37 এ হবে সেটা বুঝো গ্রুপ 7
Yes.
গ্রুপ 7 এর লিস্টে ঢুকবে আমাদের দুটো রকম লিস্ট আছে 33
My lord, may I permit it to mention?
অ্যানালগাস ম্যাটার আছে
Yes, one contempt application.
ওরা ওটা ভুলে করে ওটা
Ready to name.
7 এর লিস্টে গ্রুপ 1 এর হয়ে গেছে
Yes, call the raise list please.
Item number 2.
My lord, I am for the applicant.
I appear on behalf of the state, my lord. There is a directive to file, my lord, affidavit in opposition of the, my lord, application made by the petitioners. My lord, may I file the?
Who is the petitioner?
My lord, my lord, I have received copy.
Yes.
They have filed
My lord.
5 applications. I have given them 5.
5 applications.
5 applications, my lord.
Do you want to use a reply to these applications, these oppositions?
No, my lord, I choose not to file any reply, my lord. Kindly, the applications may be heard out today itself. My lord, these are the 5 applications, my lord.
Let me
The-
file. What are the applications
My
about?
lord, there are 3 principal applications. One being a recalling and restoration, setting aside abatement, and the third one being a substitution application, my lord. And there are 2 condonation of decrees
Both for the substitution and the recalling.
and recalling. Now, my lord, the grounds are, my lord, that there are a number of petitioners. The principal petitioners, my lord,
940 নম্বর একটা আইটেম ওটা গ্রুপ 7 হবে গ্রুপ 1 এ ঢুকে বসে আছে যেখানে
being 2 brothers, my lord, of the same family, they fell victim to the COVID pandemic, and both the brothers expired during the pandemic, my lord, in a span of 5 months. And thereafter, my lord, the family was plunged into financial crisis, being a business family. And then again, my lord, the erstwhile advocate left the brief, not for any other reason, but for her own health reason, my lord. So this is the reason, my lord, for which, my lord, the substitution application was delayed. And as the learned erstwhile advocate left the brief, my lord, that's the reason why the matter was unattended in early 2023, February 2023, when my lord was pleased to dismiss the matter for default. My lord will appreciate the well-settled law that, my lord, matter may be heard out on merits and adjudicated on merits rather than being dismissed on technicalities. And if I deal with the objections that has been filed by the state, my lord may be pleased
I
to
have
take up.
serious objection to this, my lord. One is delay is 880 days and another is 739 days. And the, my lord,
My lord,
in one application, they have said the advocate left for the
Substitution application.
substitution application. The application went to
When
the
is the
foreign
matter
countries.
dismissed?
That's why he another
it was-
thing he has the contradictory statement in the
10th
application he
February,
has stated.
10th February 2023. It was dismissed.
And when did you file your restoration application?
My lord, restoration was filed on 7th of August
23.
23. And my lord, the
1 and 2 are with regard to substitution.
1 and 2 are substitution, my lord. My lord, may I, my lord, may I say what are the exact applications by each number, my lord? My lord, can 5 is a condonation of
5
delay,
restoration and
and the delay.
condonation. Yes. And 1, 2, and 3 are abatement, substitution, and the
delay.
yes, and the delay.
My lord may be pleased to take up any of the objections that has been filed by the state, my lord, anyone. And my lord will find that they have dealt with the merits of the writ petition there. So even the
What
state
the
is,
merits, I have
even
dealt
the
with
state is
everything.
supporting my contention, my lord.
I have dealt with everything.
Any one of the objections, if my lord is pleased to take up. The state has actually dealt with the writ petition on its merits. So let the writ petition be heard out on merits.
No, my lord, first applications be dealt with, my lord.
Yes, what is your objection?
Objection is, my lord, the application has been filed, my lord. Already it has been awaited after 90 days, my lord, and 888 days delay, and almost 900 day delay, and another is almost 750 days delay. But they have not come up with a sufficient, my lord, explanation to that. Your lordship, kindly take up their application number 1.
Your application, where have you dealt with the deal? This
Yes. I have stated specifically. They have not come up with a specific, my lord, explanation, my lord.
paragraph?
My lord. My lord, I am coming. Paragraph, my lord, I. Page 7, my lord, objection, can 1, my lord.
Paragraph
I-
I is at page 5.
I, page 7, my lord. My reply of can 1. Yes. K, I, and M.
You have stated that there is no sufficient explanation, isn't it?
Yes,
That is your
no
ground.
sufficient explanation. Your lordship, kindly come to their application, my lord. 1.
My lord, 5, 6, and 7. In my applications, my lord. And my lord, in calculating the delay of, my lord, the substitution and the abatement applications, my lord, the COVID period may also be considered, my lord.
And what is your objection to the restoration application?
My lord, your lordship, kindly come to the, my lord, can 4, application for recalling, my lord. Page 5, para 3. That however, on 10th February, due to inadvertence of the learned advocate of the petitioner, who at the said time was outside the country, the said matter was left unattended. Which country, when did he go? Nothing has been explained. And therefore, the said matter was dismissed. And then, my lord, the aforesaid learned advocate of the petitioner since left the briefed 4 due to her heart ailment. Which statement is correct? My lord, para 3 and para 4. This is completely a contradictory statement given in the application.
Yes, how do you explain this?
My lord, there is nothing contradictory, my lord. The person had a heart ailment, and for that reason she went abroad for a treatment. And this is the only reason, my lord.
This is from the bar, my lord. This is
Then
not
she
from the
left-
pleadings.
Then she left the brief.
Then she left the brief,
Is that all your submission?
and that is the reason why I have come, my lord. And also, my lord, one thing, this restoration application, this we were totally in the dark about it, because that person is seriously ill. She traveled abroad, and probably she's staying there now.
He should have annexed
that is my-
the medical
my instruction.
certificate. He should have annexed the when did he went there.
Of the advocate. It is on the ground of the council.
And that is the reason why my lord will
I
find
don't think
that
further submission is necessary. All the applications are being allowed. Please fight it out on merits.
Finally, fix a date, my lord.
Can 4 and can 5 again in. Can 4 and can 5. These are applications for recalling the, for restoration of the writ petition which was dismissed for default by an order passed on 10th February 2023 and condonation of delay in filing such application. So, এর আগে একটা line করুন। Affidavits in opposition, we can first line. Affidavits in opposition submitted on behalf of the respondents are taken on record. Learned counsel for the petitioners submits that the matter remained unattended on the relevant date since learned counsel who was entrusted to look after the matter was out of station, subsequently withdrew from the matter due to her heart ailment. Heart ailment. Paragraph, upon consideration of the submission made on behalf of the parties, comma, this court is of the view that the matter ought to be heard on merits and the petitioners should not be made to suffer due to any lapse on the part of their learned counsel. Paragraph, both the applications being can 4 of 2023 and can 5 of 2023 are allowed. Paragraph, delay in filing the restoration application is condoned. Paragraph, the application being, the order passed on 10th February 2023 is set aside. Paragraph, the writ petition be restored to its original filer number. Can 4 and 5 disposed of. There shall however be no notice to cause. Can 4 and 5 disposed of. There shall however be no notice to cause. Can 1, 2 and 3. Affidavits in opposition submitted on behalf of the respondents are taken on record. Paragraph, learned counsel for the petitioners submits that who expired 2 and 3.
went.
That petitioner numbers 2 and 3 expired during pendency of the writ petition during the COVID period and their legal heirs
কপি সাবমিট করা হয়েছে এই যে রিপ্লাই দিতে পারে
We're unable to
এটা ওদের ব্যাপার
approach this court for substitution of the deceased petitioners since they were facing financial crisis on account of the COVID pandemic and also, they suffered from immense grief and shock due to demise of the said petitioners. Paragraph, learned counsel for the respondents submits that the delay has not been properly explained. Paragraph, upon consideration of the submission made on behalf of the parties and also in view of the advent of the COVID-19 pandemic at the relevant period of time, this court is inclined to hold that the delay in filing the substitution application has been sufficiently and reasonably explained by the petitioners / applicants. Paragraph, in view of the above, can 1 of 2023, 2 and 3, are allowed in the interest of justice. The delay in filing the substitution application is paragraph is condoned and the abatement set aside. The paragraph, the applicants be substituted in place of the deceased petitioners. Stop, the cause title of the writ petition be amended accordingly. There shall, however, be no arrest costs. Urgent certified website copy. WPA te order korun. It's at the motion stage.
Motion stage.
Let the matter appear under the heading Group 1 motion on 22nd April.
Grateful one. This is my application. This is my application for recalling of your lordship's order because your lordship passed an order directing the authority concerned to consider the matter and within such and such time. In time with a direction that the petitioner will file a comprehensive representation and before the respondent number 3. Respondent number 3 is deputy director R. Deputy director R. But at the instance of the submission made by the state advocate, your lordship directed pass that direction. But after filing this representation, the office by issuing a memo says that there is no such post of deputy director. My pair is your lordship
Before the director.
Director. Respondent number 2. And all other direction to be same.
My lord, I appear on behalf of the private respondents in a connected writ petition. There's a subsequent follow-up writ petition which is appearing in your lordship's list. Not, my lord, with this matter, it's low down in the list where this order, my lord, has been relied upon, my lord, by the petitioner. Now, my lord, in the event they are seeking any modification or variation, because they're relying on this order in its present form and seeking certain rights from it.
Seek necessary modification in that petition also.
He has not taken out any application. I was only humbly beseeching if your lordship, a copy of this application can be served.
Not a party to this.
Here they have not made me a party, but there they have made me a
Let
party.
this be corrected. When that other writ petition comes up, you'll be entitled
Yes,
to a
ma'am.
copy.
My lord, may I just have a copy, my lord? My lord,
I cannot direct. You're not entitled actually. No locus in this.
I'm not a party here. I'm not a party here.
So how can the court direct the petitioner to serve a copy to you? I cannot.
In the event, my lord, the other writ petition is taken up, therefore kindly keep it open for me to make.
Not in the list at the moment.
That's not being taken up now.
No, it's not. No, it's not in the list at all. I do not find it.
My lord, page 10.
Got to the- It should be the director instead of the
Page 105, can you see one of it?
of the application.
Application.
That my representation, which I have made.
No. The commutation made by the director land to the additional district magistrate, LR and RR. Now, I feel that this is pending before the my lord.
This is a different issue. This is not the.
Can you see the subject
This is
petition
the communication between the director and the ADM LR.
on the issue of my lord petition, my lord? Can you see subject petition of Sri Forestnath J. Sarkar and 3 others? Of my lord Sajpur GS scheme, yes.
This is our earlier representation, which was not fully explained. That is why your lordship directed me to make a
He
comprehensive
has filed.
representation.
This is on 15th June 2022. When was the order passed?
My lord, 7th
After that,
December,
7th December 23.
Yes, my lord. My resolution it is pending before the ADM.
So that's a different, that's an earlier representation. After that, an order was passed. He was asked to file a comprehensive representation. It was your submission that it should be made before the deputy director.
Without instruction, I have submitted.
Yes,
Because
so
it is-
there is no post as the deputy director. It should be the director. Only this clarification is required in the order. Let that be made.
my lord,
It can also consider.
and other direction to be same.
Yes. Heard learned counsels for can have it order can 1 of 2024. Heard learned counsels for the parties. Paragraph it is submitted on behalf of the petitioners that in the order passed on December 7, 2023, in the connected writ application being WPA 16844 of 2023, this court directed the third respondent being the deputy director within bracket R bracket bracket closed comma Office of the Refugee Relief and Rehabilitation Commissioner, Refugee Relief and Rehabilitation Commissioner, third respondent to the Commissioner, Refugee Relief and Rehabilitation Directorate to consider the representation submitted by the petitioners in accordance with law. Learned counsel for the petitioners submits that where is the letter informing you that this post doesn't exist?
Yes, my lord. Page 124, 124. Last 3 lines.
That the director within bracket land, Refugee Relief and Rehabilitation Directorate has informed the petitioners by a letter dated 28th December 2023 that there is no deputy director within bracket L or deputy director within bracket R in the said office. The petitioner seeks modification of the order to the extent that direction be given to the second respondent instead of the third respondent to consider the representation submitted by the petitioners.
Like, may I interpret? Which will be made by me.
Yes, I'll say that. A paragraph in view of the above, the application being can such and such is allowed. Paragraph, the order passed on December 7, 2023 is modified to the extent that the third respondent, inverted comma rakun, recorded in the said order be read as the second respondent.
My lord.
It inverted comma, the second respondent. The remaining portion of the order shall remain. Yes,
my lord.
in view of such order, the petitioners are granted liberty to submit the comprehensive representation before the second respondents within 2 weeks from date.
2 weeks.
Within 2 weeks from date. Paragraph, the remaining portion of the order shall remain unaltered. There shall, urgent certified website.
Grateful to your lordship. Deep privilege, Your Honor.
Next. Four.
May it please the Lordship. This is my application, can 2 and 3. Lordship may recall this is the matter, delivery of our deeds are concerned. Millet, I have pointed out, and whereby Millet, my learned friend has also taken up applications by saying, actually there is no sale has been taken place. This was argued extensively, Millet, on the last occasion. Lordship was pleased to Millet express the view that Lordship was pleased to Millet recall the Millet the order and the writ will be reopened. Lordship, kindly have a look.
Also kindly come
এক সেকেন্ড প্রসিডিউর এক সেকেন্ড আমি একটু বলে নি তারপর তুমি বলবে
objection for opposition. So I have to file opposition.
very well.
Have you received a copy of this?
I have not received
No,
any.
he is not the party to the additional party. Additional party
Well,
filed by the proposed added respondent. I have served the copy of the opposition to the learned advocate who filed this application.
I am for added party. I have not received any copy.
He said Millet he is the original owner. He has not executed any sale in favor of him. Millet, I also kindly have a look the disparity of
Added, you have an objection to this? You have.
Yes. I have filed an opposition. He kindly come to the prayer person.
Serve a copy.
I have served the copy. This is
You have
the
received a
receipt.
copy?
Millet, we are
This is the receipt copy also. I
we are facing the con.
Petition.
I am the Millet applicant in can 2 and can 3.
That is
না,
the
আপনাকে
alleged
receipt
content.
করেছে।
In the written petition, what is the status?
Well, in petition he will be added.
না, আমি আর দিতে পারবো না।
What's your
আপনাকে correct
status?
করো।
I say Millet, I am the respondent. The order was passed upon me to deliver
Content, alleged contemner. That's what I'm asking. Yes.
my.
So since he has filed an application for addition of party, that has to be taken up first.
Certainly, Millet.
You say you have received a copy of this application.
Yes.
Do you want to file a reply or are you ready for the hearing?
I will file reply.
কি দরকার কিন্তু
Let him come back. Mr. Mukherjee should have served the copy earlier.
So I have served. This is the receipt copy.
Actually, Lordship, the deed number in question.
You have to be added first. Then the
Yes.
deed number will come.
আপনি কি additional party hearing করবেন?
Are you
Yeah,
ready
করুন।
for the hearing today?
Yes.
করে দিন
Or you want to file, you're saying yes to everything? Do you want to file a reply or you're ready for the hearing?
Ready for the hearing.
You do not want to file a reply to this affidavit
No.
in opposition? Very well.
that's good.
Lordship, kindly come to the addition
His application.
application for addition of part.
Let him place his
Course.
case first. Scan 3, addition of party.
No,
Can
can
one.
1 his application.
Can
Can
1.
2 and 3 is mine.
Didi?
Okay, লাগানো
Can 1. Yes. Yes, please place the matter.
The deed number in question.
page number গুলো বলে দিন।
Yes.
Can 1 application page 8. Page 8.
Page 8 of your application, yes.
Deed number 011644 of 2006.
Yes.
Is the not purchaser the property actually?
Who is not purchaser of the property? Who is not purchaser of the property?
Tomir Kumar Haldar, son
The
of late
petitioner.
Shish Chandra Haldar.
Have you filed a copy of the deed
Yes,
at page?
page number 8 of CAN application.
annex করেছেন
The copy
Yeah.
of the deed.
বলুন সেটা কোন পেজে আছে সেটা বলে দিন। ঠিকটা বলুন কোন পেজে
Deed has not been annexed.
annex এর ঠিক যেটা
He says it is annexed. Let him find out.
The
Agreement for sale.
agreement for sale is annexed in page number 11.
এক্সক্লুডেড হয়েছিল না হয়নি
No, no, no.
সেটা বলুন বলে তো হয়
The deed has never executed a registered deed.
It was never executed.
And the agreement for sale is unregistered and it is cancelled on 12/6/2006. The copy already annexed.
At page, the cancellation.
Yes.
Yes. 24.
Okay.
Yes.
And the money has been referred by the check. 49,000. Please see the page number 5, Annexure C.
Yes.
The cancellation of agreement signed by Mr. Haldar on 12/6/2006. As the agreement are not registered,
So
the cancellation.
there was no deed at all.
No, no, no.
Let us hear the objection. Yes, Mr. Mukherjee.
Lordship, first of all, Lordship, what is the locus standi of the petition? This proposed added respondent to this application. Now, this process. Kindly come page 9
Of
the addition of part. Under the Lordship, the court cannot go beyond the prayer of the application. So we have to act on the basis of the prayer. Under the aforesaid facts and circumstances, it is most humbly prayed that your lordships will graciously be pleased to allow the application for adding them as a party respondent in the said writ petition in WP number 807 of 2019, Somin Kumar Haldar versus State of West Bengal.
yes.
So, Lordship, the proposed added respondent wants to be added as a respondent in the writ proceeding. That is the prayer, Lordship.
Absolutely.
Kindly come to the order. In my opposition, I have annexed the order of the writ petitions. Kindly come page 14. Lordship, this is an order dated 18 November 2021. This is a writ petition of 2019. Hard target counsel appearing on the parties, the petitioner complains that he filed his title deed for registration before the respondent authorities in the year 2006, but the same has not been handed over to him till date. The respondent authorities admit
that all dues had been cleared by the petitioner. The correspondence of the district sub-registrar 3 sub 24 Parganas dated September 15, 2017 also indicates that the deed was ready for delivery as on the date. It is submitted by the learned counsel appearing on behalf of the state respondent that it is to be ascertained whether original deed was handed over to some other person, including the representative of the petitioner. It is not in dispute that the original IGR was misplaced from the petitioner's custody and GD&T was lodged on 20th June 2012. Learned counsel appearing on behalf of the state respondent seeks time to take necessary instruction as to whether the original deed is still lying with the registrar or has been handed over to some other person. Let such instruction be taken by the learned counsel appearing on behalf of the state respondent within a fortnight from this date. Now, Lordship, this is the matter was fixed on 8th December 2021. Now, Lordship, kindly come after 8th December when matter come, 9th December's order, which was a disposal order. Pursuant to the order dated 18 November 2021, necessary instruction have been taken by the learned counsel appearing for the state respondent. It is submitted on behalf of the state that on instruction that the original deed is ready for delivery and is lying with the office. The deed also be handed over to the petitioner upon compliance of certain formalities, including swearing of an affidavit annexing thereto the copy of the GD entry indicating that the original IGR was misplaced. View of the above, the writ petition is disposed of with a direction upon the state respondents to hand over the original deed of the petitioner upon compliance of formalities of the petitioners. As mentioned herein above, the petitioner shall meet the said requirements within a week from the date, and the deed shall be handed over to the petitioner within a week thereafter. With the direction WPA such and such is disposed of, however, there will be no order as to cost since no affidavit has been invited. The allegation contained in the petition are deemed not be admitted. Urgent certified copy. So, Lordship, this order, writ petition, already has been disposed of on 9th December 2021. So, there is no existence of the writ petition at present, unless this recalling application filed by the state respondent is allowed. So, Lordship, till the recalling application is heard, this addition of parties has to be, Lordship, for the better benefit to the proposed and respondent, has to be kept in abeyance. Because there is no other option.
I propose to deal with all the three applications together.
Yes, Lordship, I have no problem. Lordship, now, Lordship, this addition of party has no right at the present moment because the petition already disposed of. Now, I have filed a contempt application. Now, contempt application, Lordship, is between the court and the alleged contempt. So, the proposed added respondent has no right of audience in the contempt application.
No.
Has no right of audience.
The added party is the necessary party.
Please wait, sir.
Now, Lordship, the proposed added respondent, after disposal of the writ petition, in spite of knowing the fact that writ petition, he has a knowledge that writ petition is pending, after a long time, at least 3 years.
Where do you show that he had knowledge that the writ petition was pending?
Kindly come, my Lordship, the affidavit in opposition.
Yes.
Lordship, I'm praying for page 6 of my opposition, paragraph Roman 4, Roman 5. Lordship, just I have.
Yes, but he is not seeking to be added in the contempt application. He doesn't want to be added in the contempt application.
In the writ petition.
Yes.
The writ, Lordship, that is my opposition.
You have
He has
just-
no, he has,
You have just stated that despite having knowledge of the writ petition all throughout, he has chosen to file the application after a certain delay.
yes,
Where is that averment in your
Yes.
opposition?
I have stated.
And how have you come to such a conclusion that he was aware all throughout? What is the basis?
Lordship, a suit is pending between the writ petitioner and the proposed added respondent. Suit is since long time regarding the same property. That he has not sold this property. Lordship, the suit has been filed by by them. That the suit is pending. Status quo has been directed to be maintained.
And the same issue has been agitated by you in the writ petition,
No. I have only prayed for delivery of the deed, original deed.
where they say that the deed was not executed at all.
Not executed at all.
That is their allegation. That after the disposal, long time suit has been filed. Also, kindly see
The
when
suit
the
is pending.
suit has been filed. When the suit was filed,
Has the suit been disposed of?
no, suit is pending. Suit was filed in 2020. Still 20, the suit is pending.
The
Suit
suit
regarding
is,
the declaration of title and permanent injunction.
suit is with regard to the same deed which you have asked for in the writ
Yes,
petition.
yes, same property.
So, Mr. Mukherjee, could you have done this?
With the
No,
petitioner.
I have, Lordship, this is my legal right for getting back the pending deeds.
Even when the deed is under challenge, execution is under challenge.
Lordship, is a declaration of title and permanent injunction. This is the suit.
On the basis of the deed which is under challenge.
Deed had never executed.
In the suit, execution of the deed is under challenge.
Lordship, the state respondent before your Lordship, Lordship submitted that the original deed is ready and is supposed to be delivered. They have admitted before your Lordship
That was
deed
the that was the
Sir.
mistake on the part of the registered department.
Please take your seat, sir. 1 minute.
that deed will be delivered. That is the submission, admission before your Lordships. Now, Lordship, in terms of your Lordship,
There has been subsequent event after that.
Right.
At the time of delivery,
Like-
it was found that it was not the same deed. The names did not match.
no, that is in the contempt application. They filed an application. Lordship, this application not in stage. I am on the addition of party stage. I will come to the recalling application. Then, Lordship, I will deal with because recalling application also has been filed after long back 2 years.
If everything is not matching, how can he claim for the deed?
Sir, let him complete. The court is speaking for you.
The recalling application also has been filed after period of 2 years. I have filed an opposition against the condonation of delay. Lordship, that has not been allowed till date.
So this is your submission for the addition of party application, right?
Addition of party application, the proposed added respondent has no right because the writ petition already has been disposed of. Unless and until writ petition is survived, the proposed added respondent has no legal right because this is a contempt proceeding is pending. Now, Lordship, kindly, this is the another aspect. The another aspects of this, Lordship, the proposed added respondents concerned. So far, the execution of the deed. Now, Lordship, kindly come to consider some relevant dates. Lordship can also compare it
Do you
from
have
this.
a copy of the plaint of the title suit which is
Yes.
pending? I would like to see the document.
This is the amended plaint. Lordship, this is the amended plaint. Lordship, kindly excuse me for marking is there.
The written statement.
statement filed by them.
Do you have a copy of the written statement with you?
No.
I
Not
would,
at, not at time.
Also, I'll produce the written statement. Lordship.
before we proceed further, I need to see both the copies.
I'm sorry, Milord.
I need to see both the copies. This is the
Yes, your
plain
lordship, please.
where it is said that there was an agreement of sale, then a deed was executed. So I would like to see whether
It
that
never
execution-
executed.
Darang na.
have you challenged that before the civil court?
Yes,
Yes, you've challenged the execution before
No,
the civil court.
I have there. I have written objection there.
Yes, what is the written statement there before the civil
I
court?
have not ready at
Do
present.
you have a copy of the written statement with you?
At present, it is
Can you
not.
produce it on the next
Yes,
day?
yes.
Lordship, may I clear two things, Lordship? Lordship, kindly bear me for a minute. Lordship, kindly, I'm just placing some dates. Lordship, these dates is available in the writ petition. Lordship, the agreement for sale, which is annexed in the application for addition of party, was executed, that is admitted by both the petitioner and Lordship the proposer and respondent. This agreement for sale was executed on 22nd April 2004. Lordship, this is admitted fact.
Yes.
Now, according to me, Lordship, according to the state respondent, when the writ petition was known, Lordship, the registered deed was executed, Lordship, pending registered deed was executed, Lordship, on that is 2006. Kindly keep this. Yes, 8 March 2006. Also, kindly note that this deed was executed before the registrar through commission 8 March 2006. Now, Lordship, kindly come the addition of one. So, how he has a legal right? Just I'm placing some documents. Kindly see page 24.
Yes.
Kindly see when he is saying the cancellation of agreement when executed. Surprising, a deed has been registered under the Registration Act 1908. That registration deed has been cancelled only after getting a signature without any registered document. Simpler, a stamp paper of stain.
Agreement for is unregistered.
1 minute. Have you challenged this before
Agreement.
the appropriate forum? The
But-
cancellation?
This cancellation, Lordship, this is the first time they have produced before this court that this is the cancellation agreement. And it's an unregistered document.
Agreement. That was agreement for
the-
sale unregistered. And that the cancellation is unregistered.
I have heard you, sir. Please have some patience.
Okay.
Lordship, a
That is the
registered deed.
that is the exact reason why I would like to see the written statement of the plaintiff, of the suit.
Lordship, a registered agreement
That is
which has
according
been
to you.
duly registered has
According
been
to you.
cancelled on a scrap of paper.
That is your version, sir. I would like to see the written statement also. I will not proceed before that.
Agreement for is unregistered.
Arey baap,
It has been registered by case.
Sir,
No,
the
no.
court has understood for the first time. You don't need to repeat 5
আর কিছু
times.
বলতে হবে না। নেই তো দেখাবো তো।
And Lordship, this date of cancellation long after the date of registration.
The same day, 12th June 2006.
12 June 2006, it was cancelled. But in my case, the deed was registered on 8 March 2006.
Never executed.
Whether there was at all a registration, this has to be looked into.
That is the case of the writ petition. That is the
That
case of
has
the
to
writ
be
petition.
looked into by the civil court. The writ petition will
Right.
not be maintainable at all if this is the fact. That is why, Mr. Mukherjee, I'm sorry to say this. Writ petition, you are aware.
Lots of writ petition has
The
been
same
disposed of.
issues have been taken. I'll recall my order. This is shocking to
2
the
years.
conscience of the court. Which
After
is
2 years, Lordship, when there
shocking
is no
to the
explanation.
conscience of the court, which is sufficient to recall an order.
Court have the plenary power, Milord. This has been, Milord, given in the
This is
Yes.
this is actually
apparent from the record,
this
Milord.
is shocking.
Absolutely.
The
Milord, the
same-
manner this has been manipulated, this is absolutely shocking.
Not
Now,
only
state
that, it is-
respondent who admitted before your Lordship that
And
we
it
will
is also suppression of material facts.
Yes,
From
yes,
his
yes,
side, from
exactly.
his side,
Exactly.
The
Exactly.
same issue is being dealt with by the civil court.
which I cannot get directly, I cannot get
Uh,
indirectly as well.
I would request you to come back with a supplementary affidavit annexing these two documents. Yes, Mr. Counsel.
हाँ ठीक है लॉर्डशिप काइंडली मिलट
Will you come back on the next date with these two
दाঁড়ান
documents?
এক মিনিট
The deed in question is that has he is claiming registered is a different person and that as was a that was a
And you-
garage.
Can you come back with these two documents on the next date?
What document required?
মিলট আই ক্যান এক্সপ্লেইন
Please explain. Please.
যে দুটো আপনি দিয়েছেন ডকুমেন্ট দুটো এই দুটোকে জজ সাহেবের হাতে তুলে দিয়েছেন
No, no,
এই
he's
দুটো
not given this, sir. Mr. Mukherjee has given this.
আচ্ছা অলরাইট রিটেন স্টেটমেন্ট এন্ড দি ডিড
And the amended plaint.
অ্যামেন্ডেড প্ল্যান
Of
এই
the
দুটো
title suit.
সাপ্লিমেন্টারি করে জজ সাহেবকে দেবে নেক্সট ডেট ঠিক আছে অ্যাফিডেভিট ফর্ম সাপ্লিমেন্টারি অ্যাফিডেভিট
The amended plaint and the written statement filed in the suit. If there is an amendment of the written statement, please come back with that also. I would like to see these. That will solve the problem.
I have if
That
you
will make everything clear.
on
Kindly note-
one thing Millard one thing just one thing lordship kindly have a look to my can two once
Necessary at this stage.
I think
Why don't you come
I
back on the
think-
next date?
just one thing
Can two, one.
can two kindly straightway come to the page 8
Page 8.
page 8 lordship sees
Yes.
the table. Millard, the entire table doesn't match. I said, Millard, the deed has been registered and we are ready to deliver it the same. Millard, we are still on the same footing.
It is this deed.
This is a different deed which is not matching with the Millard vendors and also the owners.
Nothing is matching. The
Nah,
address, the
nothing.
address is.
And one more thing, Lordship, also kindly consider the IGR is missing. From the very beginning,
IGR
suspicion is
missing there.
Millard is there.
A GD was lodged for.
It is law.
I'll deal with the matter next.
Very
It will
well.
be disposed of. It's a very short matter. I only need those two documents.
Assistant magistrate.
But Lordship, kindly
And Gulu an action.
Lordship,
1,
kindly
2, 3.
kindly consider one thing. Lordship, so far the recalling application is concerned. And Lordship, let the section 5 application file to the recalling application. Because there is a long.
You have filed an application for condonation.
I have.
There is an application for
application.
condonation.
I have filed an opposition to the.
Mr. Mukherjee, I'll dispose of everything on the next date. And you being a sufficiently experienced advocate, you know what has happened.
Lordship,
I would not like to disclose anything further in court today.
My-
I'll dispose of the matter.
my-
Your lordship,
ছেড়ে দিন না হয়ে গেছে তো
Lordship, kindly visualize
I
the
have seen,
situation.
I have visualized.
The
That's
state,
why I want to pass this order.
the state has submitted that we will deliver the deed. Now the state is stands in the different angle.
I'll
after
consider.
scrutinize everything when the cat is out of the bag
I'll deal with it. I'll
my
deal
lord
Don't worry. I'll
What
deal with it.
prevented them to
Third
scrutinize
learned
at the
counsels
relevant
for the
point of
parties.
time?
Paragraph, let the matter appear under the same heading on same heading.
boy
9th April.
আমি বলি
9th April should be sufficient.
আমি লেট সরি
9th April,
Lordship, may I prefer Friday, Lordship, Friday,
Friday.
any Friday?
Mr. Mukherjee is keeping the energy for the rest of the week
Friday, the Sumai Friday.
Then I am surprised. Friday. 5th April.
Lordship, may I get back the copy of the
I
plan?
made myself clear. Those two documents.
I will lordship kindly indicate also in the lordship's order so that I can explain once again to my lord
Third, যেখানে বললাম না, let the matter appear এর আগে করুন. Third learned counsels for the parties, তারপরে করুন. Since admittedly, a title suit is pending by and between the parties, comma, the proposed added respondent is directed to use a supplementary affidavit on the adjourned date, annexing copy of the annexing all relevant documents pertaining to the suit, including copy of the amended plaint and written statement. তারপর let the matter appear.
Lordship, may I get back the copy of the?
Yes, yes. ওটা ফেরত দিন। Next.
Lordship is indicating to file it or to serve us in an advance copy
No, because
on the same date.
because he's the plaintiff in the suit.
Very well. He has the knowledge.
He should be having
Yes.
knowledge.
That's a copy of the opposition be kept with them. Opposition to the addition of.
It is filed today.
Yes.
Affidavit in opposition. শুরুতে affidavit in opposition submitted
আজকেই দিলাম কালকে affirm
in
করা।
respect of
কালকে
can 1 is the addition. 1 of 2024 is taken on record. First line.
কালকে affirm করা আছে।
Next.
Obliged, Lordship. Give them. Give them.
14th March it is. Get.
Yes, complied.
No, Lordship, it is not complied, Lordship. Lordship, can 1 is also pending. Lordship may dispose of can 1, Lordship.
Can 1 is what?
Lordship's recalling of Lordship's order dated August 10, 2022, Lordship.
Filed by you.
Can is filed by me, Lordship, by the petitioner.
After disposing of the contempt application, Lordship, he filed the can application for recalling of the order.
Lordship
At
had
that
passed
time,
the-
Lordship, payment of gratuity has been already made by the certificate officer, and
Lordship-
only the Lordship compound interest part is due. And in this respect, Lordship, some step has been taken.
This
Kindly
was
see the-
submission on the last date also.
Yes, last day also,
Lordship.
and
Lordship, the submission of
Lordship,
the certificate officer was that they
on-
have complied with Lordship's order.
same matter, Lordship, appeal has been preferred before the Honorable Justice T.S. SUVRA, and kindly see the judgment, Lordship,
এই মামলা
para 6, Lordship.
You are asking for recalling of the order of the contempt application.
Yes, Lordship.
Yes.
Lordship
is
had passed
possible.
an order. আরে বলতে দিন ভুলভাল সাবমিশন করেছেন Lordship had passed an order on 10th of August 2022, Lordship, upon the submission of the advocates appearing on behalf of state,
Kindly see
that
the Honorable
Lordship's
Division
order
Bench
in the
observation,
requisition
Lordship,
was complied with,
and
which was not, which is
some
repeated.
step has been taken, Lordship.
Some
In spite of that,
taken,
you
Lordship.
appear before the certificate officer, they will decide.
It is recorded substantially complied with.
Yes.
There is a difference between
Yes.
substantial compliance and compliance. The recording was substantially complied with.
But Lordship,
Since the principal amount was paid,
Yes,
only the interest part was left, isn't it?
yes.
Lordship, interest part was contained in Lordship's order in the writ petition.
Not only
It was
that,
a part
Lordship,
of Lordship's order.
regarding compound interest,
And
some
since
step has
then,
been
since
taken, Lordship.
no step has been taken.
Lordship, kindly see the step has been taken.
Some
Wrongly submitted, Lordship.
Lordship, kindly,
See the certificate officer states, Lordship.
kindly,
And even the Lordship, same matter, Lordship, appeal has been preferred before the Honorable Division Bench. The Division Bench observation lights. Kindly see the paragraph 6, Lordship.
ডিভিশন বেঞ্চে একটা অর্ডার দাও দেখি
Paragraph 6, Lordship, we are kindly quoted mark. Lordship, we are of the opinion that this question regarding the payment and the settlement of gratuity dues under the terms of settlement, page 5, Lordship. Got it? And claim for compound interest, etc., should be decided by the certificate officer, not by this court.
So have you decided the interest?
Yes, Lordship, but
Really?
in spite of that, Lordship, they did not comply, Lordship, concerned company, Lordship. That's why the warrant of arrest has been issued in 2 different occasions, Lordship.
Lordship's
If
order
necessary,
dated-
Lordship, kindly direct me to file the affidavit, Lordship. What step I have been taken or not?
Lordship's order dated 22nd of March 2022, Lordship, therein Lordship directed to dispose of the certificate case pending before him within 2 months from the date of communication of this order after giving reasonable opportunity. The certificate proceeding has not yet been
Same
disposed of, Lordship.
matter, Lordship, the Honorable Division Bench observation is that not only that Honorable Justice I.B. Mukherjee also passed the same point, Lordship.
Of the certificate debtor.
Lordship,
There is a direction for arrest of the certificate debtor.
Yes.
Lordship, there has been orders, but nothing is done by
What
the
he
certificate.
said.
Nothing effective has been done.
The amount has to be paid by the certificate debtor, not
Yes,
the
yes.
not the certificate officer, is it?
No, no,
Not
no,
the-
Lordship.
So he has taken necessary steps. So I do not
But-
find.
But Lordship's order in the writ petition was to dispose of the certificate proceeding, Lordship. Lordship's
What further
specific
steps
direction
can the
was given.
certificate officer take? He has issued a direction for warrant.
After
But
issuance of a
Lordship, the
warrant,
certificate proceeding has not been disposed of. It is pending, Lordship. That is my point, Lordship.
I do not think there is any further anything is necessary in this matter.
But Lordship, if
I have to dismiss your recalling of the application.
yes, Lord.
but Lordship, then
Pass
the compound interest will never be
Why not, Lordship? A
Has
step has been
Has
taken.
done what he was supposed to do. Now the court cannot give
And
any further
If
direction.
not paid,
Lordship,
they go
Lordship, they-
The
Lo-
certificate of.
prefer the execution proceeding, Lordship.
Yes.
Lordship, the
Alternative
certificate
remedy is
officer, the
they are
certificate officer may direct the concerned police station to arrest the alleged
The
contemners.
direction that has been given.
But that only, Lordship, nothing more has been
What
done.
more? He cannot go and arrest himself.
No, no, the police station will go. The certificate officer has to follow up with the police station, Lordship.
So
Then
please
where
take-
will the poor person go,
you have to
Lordship?
take necessary steps. Certificate officer has done whatever he was supposed to do.
But
You
final
cannot expect
disposal,
anything further
Lordship,
from that.
Lordship,
When the police authority takes steps, he'll finally dispose of. I don't think anything further is here. in this
Lordship, the final disposal of the certificate proceeding is pending, Lordship. Lordship's order has not been complied.
Her learned counsels for the parties. CPL along with CAN 1, Corbin, huh? The applicant has prayed for recalling the order passed by this court on August 10, 2022. On the ground that though it has been recorded that the order under contempt has been substantially complied with, comma, the alleged contemner has not complied with the order in its entirety, since the certificate case has not been disposed of in terms of the direction given by this court. Paragraph. By the order passed on 10th August 2022, comma, this court disposed of the contempt application with an observation that the order under contempt has been substantially complied with. Stop. Today, the alleged contemner produces copy of a letter issued to the officer in charge, comma, Hare Street Police Station, comma, Kolkata 7,12,000 on 1st March 2024, directing the latter to arrest the certificate debtors unless they pay the sum of rupees 78,813 due to the applicant. Paragraph in view of the above, this court is inclined to hold that the alleged contemner has substantially complied with the order under contempt. And there is no reason for recalling the order passed on 10th August 2022. Paragraph in view of the above, the application being CAN 1 of 2022 is dismissed. There shall, however, be no arrest to cost as in certified website law.
Much obliged.
Grateful, Lordship.
So the next matter, Malad, the Lordship remembers, Malad, this is that matter where National Highway, Malad, we were supposed to Malad, take all the persons who were there. And there was a contempt, Malad, with regard to Malad, the Chief Secretary. Now, Malad, the other side was directed to file an exception. And we have not received any exception, Malad. I don't think.
দিদি পরেরটা কল করতে হবে
Appellant and
Item 6.
Lordship, we are for the I am for the appellant and we are ready for the exception, but affirmation is not complete because of the petitioner is not appear before the court because he is 85 years old and he is suffering heavy fever. If you can,
That matter, but if your lordship remembers, but I was really admonished by your lordship, but I could.
Let's come back to it.
Also keeps it next week, Malad. In the meantime, if he wants to file a
yes, Lordship.
exception,
Only affirmation is pending.
Next week you can file your
Yes,
exception.
Lordship.
Please serve an advance copy.
Yes,
I'll be
Lordship.
very grateful.
Learned counsel for the applicant petitioner seeks extension of time to use the exception to the affidavit of compliance as sought. Paragraph, let the matter appear under the same heading on 5th April.
Fine.
How are you now? Better?
I'm better, Malad. I'm on both my legs, Malad.
That's good.
And I tender my apology when I know that 11:30 was fixed, Malad. But I thought, Malad, I just.
So,
I'm very grateful.
36 matter, item 59.
Only one more in that as well.
Next matter, Malad.
My lord, he wants to file an
36
opposition.
Malad,
I have taken the permission of my senior, my lord, Mr. Mitro.
already taken
My lord, he will check just a minute.
Malad, he will,
Because
he will
he's
file,
not-
my lord.
He said that he is not going to be there next week. That is why, my lord.
That
The rest is on you.
come back to the, they are,
My lord, only she will file the.
they're all, it's already 11:30.
My lord,
I'm
already-
almost
my
11:40.
lord,
I don't think I can deal with this.
Much okay.
Especially fixed matter.
Take up this matter, possibly it will continue till 12:30. I ask.
Is it? Yes. Continue till 12:30.
Maybe continue.
I will just start, Malad. I will just start. Mr. Purokayastha will take over. On the point of jurisdiction only.
Some other matter, till 12:30.
Other matter relief করে দিন, হ্যাঁ? এটা ওই এটা, হ্যাঁ, হ্যাঁ, হ্যাঁ। এটা দিন আর রিট পিটিশনটা দিন, ব্যাস। হ্যাঁ। ব্যাস, আপাতত এটা।
Didi,
Other matters 12:30. 12:30 of the matters will release.
Other matter released till 12:30 except 59.
Malad, if your lordship,
Yes.
if your lordship remembers the argument advanced by learned senior advocate Mr. Mitro on the point of jurisdiction of this honorable court, my lord, three elements in the writ petition were being pointed at by Mr. Mitro. The first element was from the cause title itself. It appears that all the respondents are from the state of Assam. All hails from Assam. This was the principal issue that was being agitated. Secondly, my lord, the second element that was taken over by Mr. Mitro was the impugned notification at page 1080 of the writ petition, which is under challenge, is a notification issued by the Deputy Commissioner Thubri, Assam, which is also outside the jurisdiction of this court. And thirdly, the property in question involved in this writ petition, the acquisition of which has been put to challenge before your lordship, is also outside the jurisdiction. My lord, if your lordship kindly takes up, and I've made a ready referencer of Article 226. The answer to this question is itself embedded in Article 226 of the Constitution. It is just a printout.
Yes.
The power of High Court to issue certain writs. Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within whose territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them, for the enforcement of any rights conferred by Part 3 and for any other purpose. This was 1. And 2 is most relevant here, my lord, because this is the jurisdiction that we are beseeching your lordship to embark upon to decide this matter. The power conferred by clause 1 to issue directions, orders, or writs to any government, well, these are very important words, to any government, authority, or person may also be exercised
by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises. These are very relevant words, my lord. Arises for the exercise of such power, notwithstanding, this is the crucial part, notwithstanding that the seat of such government or authority or the residence of such person is not within those jurisdiction. Now, what we have challenged here, we have challenged an impugn notification. My lord, if your lordship kindly takes up page 80 of the writ petition once. The impugn notification is relating to the acquisition of Matiabak Palace, which is the subject matter in question before this honorable court also, ma'am.
Page 80.
Page 80 of the writ petition.
Yes.
Dated 10th of October 2022. Now, this is being issued by the Director of Cultural Affairs, Assam, Guwahati 1, to the Deputy Commissioner, Dhubri. This was questioned by Mr. Mitra rightly that it was an internal communication which ought not to have been challenged. But this is the outcome of a proceedings that has been initiated behind my back. It is evident on record, if your lordship kindly recalls, page 202 of the report, the thick volume, my lord, that is also lying before your lordship. Now, this is in relation to, the impugn notification is in relation to a property which is at Assam.
Page
80 of the notification, and the report, my lord, page 202. Relevant, it starts at page 201. This is where I join my issue.
Yes.
How this court is having the jurisdiction. First, my lord, I will read page 80, then I will take your lordship to page 202 to show what decision has been rendered by the Deputy Commissioner. Now, this notification at page 80, which is under challenge before your lordship, has been rightly pointed out by Mr. Mitra, my lord, that this has been an internal communication, but this is just an outcome of an acquisition proceedings that has taken some considerable time in the state of Assam to take over. Now, this notification is in connection with a property, which is the Matiabak property belonging to Raja Prabhat Chandra Borua, which is also the subject matter of partition before the Honorable High Court at Calcutta. Now, this is where we join this issue, my lord, that if your lordship now reads paragraph page 202 simultaneously, page 202
yes.
of the report. This has a strong connection and a bearing. Yes, of the report.
This was stated yesterday also.
Yes. I am also relying on this, my lord. I was just joining an issue what my senior only joined that day. Page 202. Now, the 17th October, we made a prayer. This petitioner made a prayer before this authority. Now, the outcome of this, if it has been read over by Mr. Mitra, Mr. Puragastu also, my lord. I'm not going to repeat once again on this, but but my humble submission before your lordship is that this decision taken by this Deputy Commissioner and the Circle Officer in their office, giving a complete go-by to the representation, is nothing, my lord, but it has been acted upon. The Deputy Commissioner has acted in a manner like a civil court, going on to declare the share of a party based on a family settlement of 1963, which was actually the discharge of duty of the civil court to finally look into. Now, he could not have gone into this codicil issue. He could not have gone into the family settlements, knowing fully well that there is a pendency of a civil court suit before the Honorable High Court at Calcutta. Now, this is also an issue which is attracted by Section 52 of the Transfer of Property Act. Now, simultaneously, my lord, with this notification and with this minutes at page 201, and
this has not been challenged.
No, this has not been challenged, but I'm just joining my issue over here. How we have a jurisdiction, because this is now on record. Now, with this decision being taken, my lord, the partition suit has been partially made infructuous in respect of the Matiabak property. This is most crucial issue because my right to property, as enshrined under Article 300A of the Constitution, has been taken away. With this notification coming in the way, because the civil court jurisdiction has been taken over by this authority of the state of Assam.
This order should have been challenged.
Yes, my lord, this has been filed by the state. What we had at that point of time, my lord, for the writ petition to be filed, we have enclosed. There was a deficiency of documents because the state was not providing us. And we really rushed to the court at the last point of 11th hour only. And this is a report which was a confidential report altogether, which was being produced by the state of Assam before your lordship, pursuant to the interim order being passed by your lordship. Now, this particular property, Matiabag property, with this decision coming in the way, followed by this page 80 notification, my lord, it is an outcome of this decision being taken. And this notification coming in the way at page 80, my vital right to property in respect of the Matiabag property, which is also a scheduled property in the civil suit pending before the Honorable High Court, my chunk of property has been taken away. My lord, this is how the court should have a jurisdiction to really go into, because this is either partly or fully. Yesterday, my lord, the court has, your lordship had admitted that there is a cause of action for the petitioner to come before this court, and the petitioner has also a right to sue. Because these points have sufficiently been canvassed by Mr. Purokaisto on earlier dates. Well, the issue of jurisdiction in connection with
cause of action is fine, but before which jurisdiction?
Before this court, my lord. My humble submission is before this court, because in connection with, my lord, Article 226(2),
Yes.
as I read before your lordship should not be swayed.
Part.
Yes, not on the cause of action, notwithstanding last two lines of 202, my lord. If your lordship kindly looks into, Mr. Mitra pointed at the cause title to show that all the respondents, the state of Assam, the instrumentalities of the state of Assam, and the residents of, and the private respondent number 8 to 13 are all from the state of Assam, principally. So the court should not have jurisdiction. Otherwise, if not, we can show that the court has otherwise a jurisdiction under 226(2). Now, 226(2) is appropriate in this particular matter, because the cause of action, with this notification coming in the way, I have a cause of action because my vital right of property under 302 has been taken away. Has been taken away by this notification. It is an admitted position, my lord. Now, this court has to really look into, and the notwithstanding, the last two lines are most important here, my lord, of Article 226(2). Notwithstanding that the seat of such government, here the seat of government is the government of Assam, or the authority, the state instrumentalities whose action is put to question before your lordship, here is outside the jurisdiction. It is also from the instrumentality of the Assam, or the residence of such persons. The private respondents 8 to 13, my lord, only respondent number 4 subsequently added himself as a party, but he was yet to make any submissions. So that was a subsequent event. I am not harping on that particular issue. But 8 to 13 are also residents of Assam. But this here, my lord, Article 226, last two lines, my lord, it is irrespective of the fact.
The cause of action.
Yes, it is principally on the issue of cause of action, whether it is partly or wholly within the jurisdiction. It is partly or wholly within the jurisdiction, my lord. This is where I join my issue to say that it is wholly or partly within the jurisdiction of this honorable court, because the property in question, which is put to challenge before your lordship by this illegal acquisition process during the pendency of this partition suit before the Honorable High Court, has taken away my vital right to property. And moreover, my lord, your lordship was on the last occasion was also pleased to ask, my lord, whether there is any property that is to be partitioned in Calcutta also within the jurisdiction of this court. That is there, my lord. If your lordship kindly takes the next page of this that I just handed over right now, my lord, this two-page document to show the 3 properties are also there. This 2-page document, the 226 following page, my lord. 75 Acharya Prafulla Chandra Road property, 14 Baliganj Circular Road, and 12 Mullen Street property, Chakraberia Road. These are also subject matter, and this was shown to be one of the suit properties in
subject matter of the
partition suit. Yes, no, not before the writ petition. The writ petition property is a Matiabag Palace property, which is in Dhubri, but this is a subject matter of the partition suit pending in the Calcutta High Court. But join cause of action. My lord, that is how, my lord, we will say, my lord, the cause of action for me to come before this court challenging the impugned notification is in connection with the property, which is also a subject matter of partition before the Honorable High Court. The respondent authorities could have sought the leave of this court under Section 52. They could have kept the matter in abeyance. None of the parties, my lord, we have agitated this for the first time before this court. None of the respondents have stated before the civil court, my lord, before the Honorable High Court at Calcutta, that this property has been acquired. This is also to be noted, my lord. This is also another issue that I would like to join before your lordship.
That I think that
we have been accused of. Yes, we have been accused of suppression of facts But these are not suppression of material facts. What is suppression of material fact is that this property that was being acquired at Dhupri, this Matiabag Palace, ought to have been mentioned before the Honorable High Court at Calcutta, which is in session of the civil court, civil partition suit. Neither the private respondents 8 to 13 informed this before the civil court, my lord. Not the state was a party. So I cannot blame the state in the partition suit, but it was the action of the state that speaks for itself, my lord. It speaks volumes by itself, that the court, that the authorities could have restrained itself to say that until there is a final decree being passed under Order 20, Rule 18 of the CPC, we are not in a position to really go into this. That's on merits. But my lord, that happened because this has not happened. All these facts have culminated to a situation ultimately whereby they acquired the property under the 2013 Act in a process which is completely contrary to the provision of law. My lord, that is on merits. But this particular notification is the outcome of that acquisition process. That my lord, this amount that has been disbursed, we have challenged this particular notification of 10/10/2022, which is the outcome of an acquisition process only, because the compensation part of 1,500 crores was only there. So this has a direct nexus with the civil suit. So my lord, this Honorable High Court has absolute jurisdiction in exercise of Article 226, Sub-Article 2, my lord, because as I rightly read, my lord, before your lordship, that this particular clause on Article 226 gives me the right to come before your lordship. Otherwise, at the very first hand, my lord, we would have otherwise chosen. We were also aware of this fact, but we only chose to come before this because we wanted to test our case in Article 226, because there was a vital right that has been infringed under Article 300, manner, where your lordship should not restrain your lordship's hands in looking into the matter, because there has been a manifest injustice and my right to property has been seized, has been taken away, rendering the partition suit partially infructuous in respect of the Matiabag Palace. And that fact has not been brought to the notice, my lord, till date, either by the private respondents before this honorable court or by any other party. And the outcome of this writ petition will only have a consequence on the civil court. And this particular notification and the decision-taking process, my lord, could not have been taken, my lord. The deputy commissioner has acted in a manner like a civil court only, in declaring the share of some parties 8 to 13 and handing over them the property and giving them the money, rendering my rights, crucial rights, giving a complete go-by to the representation, giving my absolute right in the property, my lord, which is to be looked into by the civil court itself. Because there is a partition commissioner being involved in the matter and the report is to come. There is a final decree that is awaiting.
Have you approached the civil court on this issue?
No, my lord, we are to. We are to. Yes, we are a party to this. But it was the mundane duty of my lord, I would say, because the beneficiaries are 8 to 13 who are parties to this writ petition are also parties to the civil court.
The civil court will take a call on this.
Absolutely. Absolutely. Not this court. But this is, my lord, material suppression of fact on the part of the respondents before the civil court.
Not this court.
And this is, I am to say this because, my lord, a serious allegation has been put against us that there has been a misrepresentation, there has been a material suppression. There has been no material suppression. If that has been from the sides of the private respondents itself. But I believe my Mr. Puragastha will take over, my lord, for some time.
I think you have completed your argument.
I believe so. It's only
I must express gratitude to your lordship. Your lordship allowed us for sufficient time to hear this writ petition. Really, it is, my lord.
That is required for adjudication.
Yeah, you are allowed. And we got opportunity to express ourselves. The cause of action is arose within the territorial television. Because this is the vital question, my lord. Whether this writ petition, there was any cause of action for entertaining the writ petition by the High Court of Calcutta. That is the crux of the point, my lord. And your lordship is repeatedly asking me to satisfy on that point.
Yes.
So your lordship will decide this matter from after considering the all facts and circumstances, starting from on the date of the filing of the suit till 28/11. All circumstances, conduct of the parties, and pleadings, I am, my lord, writ petition. Their lordship is saying, my lord, that expression of the cause of action, their lordship, the dependence has nothing to say. It is the absolute authority of the court, of High Court, to decide whether you will entertain the petition or not. That is, your lordship will find from the latest judgment of the Supreme Court. That is, my lord, the judgment of the AIR online 220 SC 819. That question has been solved by the, because one person, my lord, he was working within the jurisdiction of Calcutta. But he filed one writ petition by Patna High Court. That has been dismissed. Thereafter, he filed another petition, my lord, Jharkhand High Court. That is also dismissed on the ground of territorial jurisdiction. Then again approached the High Court of Calcutta. Then High Court Calcutta decided that, you know, whatever defense taken by the, that is not a consideration. What consideration before the Honorable Court is, what are the relief sought for, what are the amendments, court must be satisfied from the pleadings. On reading of the pleadings, if the cause of actions arises, your lordship will admit. That stage has gone, your lordship already crossed that, because your lordship proceeded. There is the, your lordship will find a page, the judgment of the, yes, your lordship is page, আপনাকে দিয়েছে judgment, কোর্টকে দিয়েছে, Page 22. Some writing is there, my lord. I may be excused for it. Page 22 of this judgment, your lordship said.
Yes.
By raising these tricky questions at the belated stage, my lord, respondent number 8 to 13 wastes valuable time on our court. My lord, your lordship see page 6. It is well settled that expression of the cause of action means the bundle of facts which the petitioner must prove. So what are the I made in the abatements and the pleading allegation, I must prove it. If Travers is entitled to a judgment in his favor to the court, then, my lord, cause of action has no relation whatsoever to the defense which may be set up by the defendant. The defendant has nothing to say. It is the absolute jurisdiction of the court whether court will entertain or not, whether there is a breach of fundamental right, whether legal right is infringed. If I can satisfy your lordship, my fundamental right has been infringed, my right to suit property, that in Madhya Pradesh, which is asserted and claimed in the partition suit, and it is a being High Court being a protector of this case, is protected my right by granting injunction also. High Court already granted injunction in addition to section 52, my lord. Injunction also granted, restraining all parties to make any transaction of the said land, either sale or agreement, till disposal of the suit. That has been violated by that notification, my lord. So that the cause of defense by the defense, nor does it depend on the character of the relief prayed for. It refers entirely to the grounds set forth in the plaint. So your lordship will only look into my abatements, allegation and pleading. Yesterday I argued before your lordship. And they set forth in the plaint in the cause of action, or any other words to the media upon the plaintiff, ask the court to arrive at conclusions in its favor. Then, therefore, in determining the objection of lack of territorial jurisdictions of the court, must take all the facts pleaded in support of the cause of action into consideration, albeit without embarking upon the inquiry as to the correctness and otherwise of the facts. So there is, my lord, defects of plaintiff, that is there, my lord. Your lordship is to read the entirety of the writ petition. Whether I made correctly or not, that is the matter here. Your lordship will see whether the pleadings has given me the cause of action or not. That is the, then to the, or any part of cause of action, without me embarking upon the inquiry as to the correctness or otherwise of the said facts.
Just now we received a very sad news. Mr. Kapoor, senior Mr. Kapoor, Mr. Justice Kapoor's father.
Yes.
He has expired just now, this morning.
When did this happen?
Just now it happened. I'm told that all the courts have risen. I am being told just now in court by my lord.
Oh, my lord.
My God.
Number 6, my lord.
He was not well for quite some time, I think.
Very soon. In fact, my lord, yesterday we got the information that day before yesterday, we got the information that he was in a ventilator and he could hardly breathe, and he was in the ICCU of Woodlands. So, my lord, it seems that he could not pull through. Ultimately, my lord, he expired.
It has happened this morning.
My lord,
This morning.
yes, this why not this morning, just now. Because we came to the court.
That's the reason why
Very unfortunate.
So, my lord.
Yeah.
It's a great loss to the court also.
Great loss, right? My exact contemporary. We joined the profession together. And in the same chamber of Mr. Shubhimal Roy that time.
Very unfortunate. He was a doyen of the bar, yes. Yes. Very sad. Very sad.
Yeah.
So the courts are rising.
Yes, my lord. Other courts are suspended.
Is it immediately or 2 p.m.? What is the resolution?
I do not know, my lord. I've just been told this. May we get the information and come back to your lordship? I think it's better.
Is it from now itself or 2 o'clock or whatever? Whatever is the resolution being followed?
I shall immediately go to
Yes,
house.
yes, I am disturbed. I mean,
Absolutely.
It's really very shocking.
Very shocking.
Very shocking.
go there and pay our respects.
Very shocking.
Really. Let it be, my lord.
Let it be.
Personally feel we learn every day from you, the seniors who are here. We may be sitting here, but the experience that you have, I mean, this is my personal opinion.
Really, my
Very
lord.
unfortunate. Very unfortunate.
Yeah.
In fact, we grew up together in the profession. I can say that.
Really,
I
my lord.
understand your feeling.
I got him when I was presiding in the my cat. He appeared before me, and after argument, he appreciated me like anything. So that is why
Seriously,
my lord,
quite
very
some time, I think.
yes, my say very sincere advocate, my lord.
He'll be in his 80s.
Would be my age. Should be 84, 85.
We cannot start now. Let us wait for this.
Yes, yes. Do you want to continue or you're not in a position to?
I think, my lord, we need not continue.
Wait. Let me fix a date in that.
Fix it.
Yes.
Mutually.
But it's in a proper state of mind, right at this point of time.
Yes, nice.
When can you come back?
Any day, my lord, following, because the state of Assam is not being represented now.
Yes, yes.
My lord, I am appearing here. Virtually, I am appearing. My
You
lord.
heard about the mishap just now. That
Yes,
has
yes,
happened.
my lord. I've heard, my lord.
When can you come back?
My lord, last week of this month, my lord.
Last week of this month is a holiday. There are several holidays actually.
My lord,
this
next week, I believe, like we can conclude. 10 to 15 minutes we will take. I hardly think.
We can have next week.
Next week, my lord, because that following week will be
you are closing the week after. I think my learned friends, courts are closing next week after.
Are you free on 27th and 28th? Because no one is taking a date on those 2 days. Are you
27
there in town?
27, 28, my lord, he will not be here, number one.
No, he's appearing virtually in any case.
No.
I have no difficulty, my lord, 27, 28, my lord. I have no difficulty.
Those 2 days in between, no one is asking, taking a date on.
That is right.
Maybe till the month of April.
6th, 7th April, কারণ उसमें छुट्टी আছে।
Well, then kindly make it
22nd
in the month of April.
April 6th.
Can it be on 11th and 12th April?
11th will do, my lord. I believe like we will conclude because we are just responding
No,
to the
because
answers.
Mr. Mitra has to reply.
Mr. Mitra has already concluded his arguments. We are
No, let me give
He has
reply.
to give a reply.
Yes.
You are citing decisions and you are
Madam, 11th and 12th.
So shall I fix 1 date or 2 dates?
Hello, one
Days.
2 days should be sufficient.
2 days
At least
maybe.
this part can be concluded.
আমাদের সুবিধার জন্য করছি তুমি আবার one day করছি।
The maintainability issue can be concluded. 1 day for you and 1 day, Mr. Mitra.
Yes, I think.
Yes, ma'am.
Well, 11th or 12th April.
11th and 12th? Heard learned counsels for the parties.
One day will do one.
Paragraph, let the matter appear under the same heading on 11th April, 11:30 on both the dates.
Yes, yes.
11th April, bracket 11:30 AM
এটা তোমার
and 12th April, দুটোই 2024 করবে। এটাও bracket 11:30।
I was in care. They appeared people.
We joined together. The last 58 years he is my colleague. আমার বিয়েতে গেছে actually.
কি করবো? wait করবো না নেমে যাবো? Resolution.
Well, this is subject to what your lordship thinks. Well, I think your lordship should rise. And if there is any matter, my lord, they will come and mention before. And they will, my lord, request your lordship to come back. Otherwise, nobody in the court.
Because a learned counsel has gone for to gather
because
about the.
everybody is thinking at 12:30. Everybody is thinking that at 12:30, your lordship will please to resume your lordship's normal list.
Yes. Mentioning on all. 12:30 তে তো mention.
তাহলে আমি লাউঞ্জে আছি কি
Deeply obliged.